determined to encourage and empower women in business, industry, and commerce across all sectors and fields. To further this aim, Wiki's Council, wherein more than 17,000 office bearers across 850 plus councils in above 160 sectors, are working to enable both depth and width of knowledge and leadership from all strata of economy and society, and are forming the basis of policy changes at the top levels of decision making, as well as mindsets and societal transformation at the grassroots. These councils are set up at national, regional, state, city, and bilateral levels, along with three national boards: governing, advisory, and executive. These boards put forth recommendations to relevant government authorities and institutions to empower women owned businesses and to become more competitive. National Judicial Reforms Council (NJRC) is one of the councils with an aim to collaborate with government bodies, ministries, chambers, universities, and non-profits to make suitable representations and recommendations for any incentives, concessions, policy, legislative, and structural changes to work with corporates or government for studies and projects with grants and funding from them to formulate self-determination and agenda in local context, to organize delegations, and to exchange with public platforms, industries, forums, and other business chambers. We make women's voices heard.
The reservation jurisprudence of the Supreme Court of India has always been puzzling, with the court often moving back and forth between the choices it makes. It's generally accepted, at least doctrinally, if not in practice, that Articles 15 Clause 4 and 16 Clause 4 are not exceptions to the Constitution's Equality Code, but emphatic statements of it. From hearing, reservation is not an end but a means to secure social and economic justice. It should not continue for an indefinite period of time so as to become a vested interest. To reconsider it as an instrument of affirmative action by the state so as to ensure an all inclusive approach. We have come a long way. 30 long years of highly contentious issue of reservation, right from the famous 1992 judgment of Indira Sahani versus Union of India to the most recent one, Janhit Abhiyan versus Union of India. The court's engagement with this issue becomes significant due to the prior enduring consistency of its jurisprudence with respect to the necessity of a homogeneous, precisely delineated class constituting the eligible recipient of reservations under Article 15 and 16.
Recently, the Constitution Bench of the Supreme Court, led by Chief Justice of India Lalit, finalized three cardinal issues for examining whether the 103rd Constitutional Amendment, which provides 10% quota of economically weaker sections, violates the basic structure of the Constitution. In recognition of the same, and on this occasion of National Law Day, National Judicial Reforms Council, Wiki, has organized this webinar, wherein our honorable guest speaker will be discussing the key issues pertaining to this judgment. Now, I would like my co-host to introduce the honorable speaker.
Thank you, Adrita. That was indeed a well-described introduction of the theme for today's webinar. Without much ado, we'll be moving forward with introducing our vehement speaker for the day. I'm sure our audience have been patiently waiting for this. So our keynote speaker for the day is Dr. Avnish Bhatt, sir. Sir is an illustrious academician in law with an experience in teaching various legal subjects, which includes subjects like constitutional law, along with the human rights and international law. Sir has also done commendable research work in the areas of constitutional law, constitutionalism, prison-related laws, and many more. Sir is presently associated with Xavier's Law School as an assistant professor. His expertise, competence, and professionalism has truly astonished us. We are delighted to have you with us today, sir.
To dive right into the webinar, I would first like to chart out the format of the same. We aim to keep this webinar as interactive as possible. For this purpose, we will begin a series of questions for Sir at the end. So let's hear Sir's thoughts and perspective on this landmark ruling. Sir, please take up the dice.
Okay, first of all, a very good evening to all. Thank you very much for two wonderful girls who are handling the stage in the most efficient manner which I have seen. And secondly, I would like to thank National Judicial Reforms Council and at the same time Women's Indian Chamber of Commerce and Industry, who is a banner under which the National Judicial Reform Council works. And at the outset, I would like to thank the dynamic leader, Dr. Harbeen Arora Rai, who is a founder and national president of Women's Indian Chamber of Commerce and Industry, who was kind enough to invite me for this webinar in a very burning issue related to the economic weaker section and the amendment which has taken place in 2019. Before proceeding further, I also would like to state regarding the most efficient, brilliant, and intellectual girl, Miss Shalini Coppola, who is a key instrumental for having me here on this stage. So, thank you very much to all the stakeholders for inviting me, for giving me an opportunity to address the august gathering who assembled here and spared their valuable time in this discussion, which is very genuine, very relevant in the context of equality. For starting, I would like to state that I will be addressing human beings. I will not be addressing Hindus, Muslims, SCs, ST, OBC, generals. I will be addressing the human beings. So please keep this in mind that I'm not addressing any kind of gender, any kind of caste. I'm addressing to all as a human being. So to begin with, I would like to state before you one of the most important decision which has been taken by United Nations. That is, if you are not aware, the 17th Sustainable Development Goal, which state, and I read and quote as, end poverty in all its forms everywhere. And the agenda is set to be completed by 2030. So what is the rationality behind this? They have taken a note regarding poverty very, very seriously. What are the factors which leads to poverty? How the poverty begins? How one can overcome with the poverty? When United Nations is addressing and changing its dimensions and focusing firmly to eradicate poverty, we all should think over it, because ultimately we are also a part of United Nations organization, and at the same time we are a part of a human being family. Thus, the question raised in the case of Janhit Abhiyan versus Union of India, a writ petition which has invoked several questions before us, which has which are the questions are burning like anything now after the judgment which was recently pronounced. And also to quote, not to forget, that former Chief Justice of India has given the dissenting opinion and he firmly disagreed on the fact that yes, EWS is unconstitutional. So, in this session, I would like to throw some light on some pointers which are relevant of this particular case. I would like to take you to a historical perspective of the articles on the basis of which the debate has raised, and of course, other allied and related topics which are very, very important to discuss. And I will be crisp and short during my lecture. To begin with, just to apprise you, just to take you to the preamble first. So, when we talk about the preamble, my fellow colleague has already highlighted the preamble by stating the concept of justice, social, economic, and political. So, when we talk about justice, majorly we talk about the social and economic justice. When we talk about social justice, so then again the concept of equality comes into existence, that everyone should got an equal opportunity in each and every segment of life. Now, when we talk about life, so immediately what comes into my mind, and I quote, that life is not merely living an animal existence. I'm sure you must remember these wordings of Honorable Justice of Supreme Court of India. At the same time, when we talk about equality, immediately Article 14 came into existence, which talks about equality. But Article 14 is not sufficient enough to achieve real equality, to eradicate inequality. Now, the point came into existence, and I would like to correlate it with the real situations. These days, many examples which can be related to this concept, like how we judge a person, whether a person is wealthy or not. Okay, a person is having an iPhone. We presume a person is very wealthy. But my dear friends, we must not forget that there is a concept of EMI at the same time. Maybe a person is so tempted to see an iPhone, but at the same time, purchasing an iPhone and on the daily basis, on a monthly basis, purchasing different packs, it's quite difficult. We must not forget that recently our new Chief Justice of India, Justice Chandrachud, has highlighted that junior advocate should be paid well. What about the junior advocates? Maybe the junior advocate belong to a general category, but still, Chief Justice of India is highlighted on the fact that they should be paid. Why? Because of the livelihood, because of the life. So it is a requirement, it is a need of an hour. At the same time, when we talk about Article 14, Article 14 cannot be achieved single handedly, only by the bare reading of Article 14. For the perfect execution and implementation of Article 14, we will be needing Article 15 and 16 to execute it. Now, this transgression of execution of Article 14, so just my friends to highlight, and I would like to state before you that when Article 15 and 16 were in the process of formulation, just to apprise you that before the adoption and the discussion related to Article 15 and 16, what are the other instruments, what are the other documents which has played a key role in the framing of Article 15 and 16. And I would like to highlight, and I read as, so in the case of Article 15, in the formation, there was a discussion before the adoption of All Parties Committee's Report 1928. Australian Constitution 1900, Section 117. German Constitution 1949, uh, Article 3, Subclause 3. Swiss Constitution 1874, Article 4. And at that time, there's USSR Constitution 1936, Article 123. These were referred, and the reference drawn from these countries. And when in a case of Article 16, US Constitution 1787, Australian Constitution 1900, Section 116. Now, in both the articles, when the reference were drawn from various countries, one thing is common, which I want to highlight. The common thing is the countries which we have referred are developed countries. To point out, when we have passed our constitution, we are not developed. But we have drawn the reference from the developing nations, from the developed nations. The nations were already developed, their judiciary already strengthened, their rules, the rule of law are already strengthened. But we, that time still was in a process of, and started the process of development. And just to tell you that we are still in a process of development, we are developing day by day. The literacy ratio at that point of time, when we talk about 1947, it's maximum 6 to 8%. Now, when we are dealing with 1947, 1948, 1949, the sources which I have presented before you, the key factors, they are the developed nations. And just to inform you, and I would like to quote that regarding the Dr. Bhimrao Ambedkar, what he stated before the Constituent Assembly in 1948, 19 November 1948, and I quote, as economic democracy as a complement to political democracy. Is categorically he referred the terminology economic democracy. Somewhere, and at the same time, B.R. Ambedkar itself has referred specifically before related to Article 14, and he said that he is about to correct the historic injustice. There is a correction for historic injustice, social stigma, and discrimination. These are the wordings which were used in the Constituent Assembly debates, which led to the formation of 14, 15, and 16. Of course, at that point of time, illiteracy, unemployment, inequality, economic inequality, social injustice were at peak. But since then, we have provided the concept of reservations, but that too for a limited period of time. But my friend, we must not forget, still we have the reservations. It's not like that we have to stop the reservation system. The answer is no. Still, we have the reservation and it is continuous. And day by day, there were new petitions filed to include some or the other categories in the reservation system due to one or the other reasons. So I don't want to land up in the discussion related to that reservation which is existing since the inception of a constitution. Because there is a rationality behind the reservation system itself for the development of the community who were socially deprived, educationally backward. It makes sense. And can we say at this point of time whether those communities were uplifted, whether they are still in the mainstream. So, on this note, I would like to inform you regarding one of the statistics and to inform you the statistics which were presented by the, if you are not aware regarding the Mandal Commission report which led to the judgment of Indra Sahni, and at the same time this economic weaker section amendment, 103rd amendment in the year 2019, the basis is Sinho Commission report. For all your information, there is a major Sinho whose commission report has been taken as an evidence for the implementation of EWS quota. Just I would like to share with you, as per the Sinho Commission report, that commission report, that commission has hammered on the concept of EWS reservation. But at the same time, the same commission has highlighted a fact that, and I quote, that 48% ST, 38% SC, 33% OBC are in poorest. They are not poor, they are poorest. That means what? Somewhere still we need reservations. So if anyone say that sorry, we don't need reservation now, that is a report. And my friends, for your information, this commission members, they went to each and every state to study this aspect, and on the basis of their field study, first hand report, they have collected this information. Now, proceeding further, we are in a developing process. We are trying to develop the underprivileged section of the society. We are a part of United Nations organization, and at the same time we are following the sustainable development goals. At the same time, can we say that once a community which is developed is always a developed community? There may be a high probability a community which is already developed may goes down, may becomes underdeveloped community, and maybe there is a need to uplift that community then. So at the same time, I would like to refer some instances in Assam. In northeastern state, there were some petitions which were filed to give reservation to general category specifically, because there is a need, because they were in the minority in those states. So reservation is subjective. At the same time, the present controversy. So related to the present controversy, 103rd amendment in the year 2019, which is implemented from 14 January 2019, and majorly it is related to Article 15 Clause 6 and Article 16 Clause 6, which has been implemented by the government to give the quota to EWS category up to 10% reservation. So some reference I have taken from that case, Janhit Abhiyan. So what were the major issues in that petition? So the petition has raised some sensitive issues like, and I read, that whether 103rd amendment is breaching the basic structure doctrine in relation to the economic criteria, whether admission to private unaided education institution is violation, and at the same time whether excluding SC, ST and OBC from this 10% reservation is also a violation. And the last issue which was framed by the Honorable Apex Court is that whether it is a violation of 50% cap limit which was given by the 9 judges bench, Indra Sani versus Union of India. So these were the sensitive questions which were raised in that particular case. When you go through the case in details from the petitioner sides itself, several landmark cases were highlighted, and few of them I would like to quote. Before this quoting the case laws, one of the very important line which was highlighted by one of the petitioners advocate, that EWS were never subjected to any discrimination. The same I am quoting. EWS is never subjected to any discrimination. On this point, I would like to highlight some jurisprudential aspect of the approach of the realistic view. Are we going for reformatory approach, or we are looking for proactive approach? Whether we should wait for any community to be discriminated, only then we should take any action, or we should take an action now so that we can safeguard any community to go into the discrimination. So these aspects raise some sensitive issues. So if you ask me personally, is prevention is better than cure? So if we take preventive approach, precautionary approach is a good approach in a context that we should stop the disadvantage part which is going to be happen in the future. Moving further, there was a lot of discussion regarding the social injustice. There was a lot of hue and cry regarding keeping out of SC, ST and OBC in that 10% EWS quota. They have quoted the judgments like Indra Sani, N.M. Thomas, R. Balaji, Prithviraj Chauhan versus Union of India, in which it was highlighted by the apex court that the role of fraternity must be in the scheme of polity and society. And at the same time, there was a highlight that weightage should be given to SCs and ST. So, petitioners have raised a lot of major concerns regarding the community who are already get the reservation, SC, STs and OBC. And they were saying that Article 15 and Article 16 is basically articulated just for the protection of the underprivileged class, majorly the SC, ST and OBC. But to apprise you, one of the major findings of in that particular case, which was raised by senior advocate Gopal Shankar Narayan, very beautifully he has crafted his argument, and he stated before the Honorable Apex Court that the whole Constitution Amendment 103 is valid except a portion that is written that this in addition to the existing reservation. Please mind my words, which is very, very important to understand. And I am amazed to see that how beautifully the learned senior advocate has crafted his argument by stating that only a little portion is unconstitutional, but otherwise the amendment is very good and for the progression of a country. That is, that it is written that this reservation is in addition to the existing reservation. So in the existing reservation system, Indra Sawhney came into existence, wherein the Supreme Court has said that okay, 50% capping should be done, shall not be breached. That is the existing reservation system. So learned advocate has highlighted that only this portion, if it can be changed, otherwise it is valid. So But at the same time, we have seen the judgment. The Honorable Apex Court has affirmed the judgment and held that one's 103rd Amendment is constitutional. But definitely, we are going to see the judicial reviews and we are going to see how the matter will proceed further. But at the same time, I would like to quote one of the professors who have formulated or coined a theory of substantive equality and the bases which were drawn from Article 46, Directive Principle of State Policy. So, state is again duty bound to take care of the community. When we talk about the community and the society, so society includes the weaker sections, the richer sections, the middle class segments. So the state is duty bound to take care. So at the same time, whether there is a need to take care of the economic weaker section. When we talk about economic weaker section, the economic weaker section is actually targeting a whole family whose annual income is up to 8 lakh. And of course, there are some criteria which were mentioned and fixed by the government. So at the same time, whether each segment of the society getting the same privilege. So I would like to highlight the society which is below the poverty line, specially assisted by the state. How about when we talk about the COVID, COVID times, the food, ration provided by the government to the people who are below poverty line. But the facts states that there are many families from middle class segment who are unable to bear the day-to-day expenses. There are many young advocates who belong to a good family, unable to bear the day-to-day expenses, their rent in Delhi NCR or other places. These facts are undisputed. And at the same time, the world talks about the concept of inclusiveness, not exclusiveness. So, society is changing, society is developing. At the same time, the state is undoubtedly taking care of the certain classes because of the constitutional mandates, because of the directive principle of state policy. By including a separate category that is an EWS, there is a foundation again on the state to take care of some such categories which may in future goes down. What if the middle class going to the lower middle class and lower middle class further going to the poor classes? So we are talking about upliftment, poor segment to the middle class segment and then to the richer class segment. But what about the community who is going down? Equality talks about eradication of inequality. It's not only talk about equality. It's also talks about the bridging the gap between the unequals. So this is one of the step, one of the bridge which is created by the legislator to bridge that gap, to uplift a segment of the society which is now in a vulnerable class, which may go down, which is going down. At the same time, 50% ceiling. In this case, the 51% ceiling was challenged. And the words which were used regarding flexibility and inflexibility. So there were a lot of discussion which were held that this 50% ceiling is fixed ceiling, cannot be breached. But in case of Indira Sawhney itself, in Indira Sawhney, Honorable Apex Court itself has highlighted that in exceptional circumstances, it may be changed. So there was a lot of discussion in this particular case also. That is clear violation of basic structure doctrine, concept of equality, the basis which has taken that the 50% ceiling fixed by the Honorable Apex Court. So again, Apex Court has taken a very detailed approach, has gone through in detail, and has highlighted that it is flexible. We cannot say it's rigid. Now the point here is we have to compete with the change. Our constitution is not static. Our judicial precedent is always not static. It is always changing with the change requirement of the society. So if we go static, of course, we'll stop our development process. So when the society is developing, we have to develop with different ideas, different functioning, and somewhere the country needs the hard decisions to be taken. So at the same time, when you look minutely, the micro detailing of this particular case, there's no cropping of the reservation. The classes who are underprivileged classes, reserved classes, they will be getting the reservations, undoubtedly. But at the same time, the new segments, which is required, some reservations. So Apex Court has clarified that yes, constitution is for them too, for everyone. At the same time, I would like to highlight one of the celebrated case, and I quote, that is in case of Vaman Rao and others versus Union of India and others, 1981, 2 SCC 362. It was said that basic structure is the sum total of the basic feature of the constitution. I repeat, the basic structure is the sum total of the basic feature of the constitution. Now, when we talk about the basic feature, economic equality, economic justice is one of the basic feature of a constitution, which already I have highlighted when I started with the concept of preamble. And at the same time, I would like to quote E.P. Royappa versus State of Tamil Nadu, where Justice Bhagwati has highlighted a term, a way of life, in inverted commas, and said it must not be subjected to a narrow, pedantic, and lexicographic approach. So Justice Bhagwati has highlighted that we have to take a very wider approach when it comes to the concept of a way of life. So when we talk a way of life, we need economic equality also. One cannot deny, or it is undoubted fact that equality, achieving equality, it's very economic equality, it's very difficult task. Everyone at par in the matter of economy, it's very difficult. But at least one should try to eradicate inequality. That is a major concern, which was now protected by the Honorable Apex Court in this particular case. So lastly, I would like to conclude this because we would like to have some questions. So I would like to conclude and I would like to highlight one of the most celebrated case in related to reservation system, that is KC Vasant Kumar versus State of Karnataka 1985. in which it was highlighted that lower the caste, the poorer are its members. But in that particular case itself, it was accepted that poverty is an indicator of backwardness. So when you eradicate poverty, automatically we are upward, not backward. So with this word, I would like to thanks the organizer. Of course, the we can speak and we can discuss the thing for 3 hours, 5 hours. This is an endless discussion. We need to stop somewhere. But my personal notion on this judgment, that I personally welcome the judgment of Honorable Apex Court, that they kept in mind the concept of inclusiveness. But I'm also keen to see that how this matter now go will be going further, how the Supreme Court is going to deal with the further petitions or further reviews is going to be taken by the Honorable Apex Court. That is tempting to see. As a researcher also, I will be very keen to study this aspect further in the light of judicial pronouncement. So with this note, I would like to thanks to organizer, the audience who have spared their valuable time in listening to me. Thank you very much.
Thank
Thank
you
you.
so much, sir. So we will go ahead with the first question. That is, why do we need reservations in jobs and further promotions when it is already given to us during our education?
During our
Education.
okay, there's a concept of equal representation. So everything is rooted to socially and educationally backward. At the same time, there are many classes who are not equally represented in the jobs itself. Specifically, categorically, if we speak about scheduled tribes, just to inform you, you please go through the notifications. You will see the ST jobs coming again and again, again and again. Just to inform you that IIMs now started a special recruitment drive specifically only for the reserve classes. The rationality behind it, that they want to take these segments into the mainstream. They're not turning up, they're not coming, maybe due to any reasons. So that is why, to achieve real equality in the terms of employment, many jobs were specifically reserved for them, to pull that community to come and join to that segment of a job. So maybe their future generation will get the benefits of it. And just as I told you, if you can see the notifications, there are thousands of jobs re-advertised, SCs and STs specifically, because those jobs were not filled as of now. But have you seen the general category jobs re-advertised? Very rare. So still there is a push which is given by the government to take these community into the mainstream. And at the same time, we are also majorly relying upon the data of India, like population census, data related to poor, data related to the middle class segment. So when you go through the data, there may be a counter opinion that data may be manipulated. Of course, data may be manipulated. But my point is, please work on the ground level. Work with some NGO. You will know the reality.
Totally agree with your point, sir. The second question comes like they say that isn't it true that the reservation is not for financial stability, but rather it's the only thing that is somehow making things chaotic?
I am unable to hear. Just a moment. Let me switch over to the earplugs.
Yeah.
Yes, I'm audible.
Am I audible now?
Yes, yes, yes.
Yes. So someone has asked that isn't it true that the reservation is not for financial stability, but rather it's the only thing that makes somehow makes other things more complicated and chaotic.
All right. So my personal opinion on this, based on the research work, it's not to make the things chaotic. It's to make the things simpler and more simpler. From chaotic, we are shifting from chaotic to simpler. From underdeveloped to developing, and now we are in the facing phase of getting and achieve the status of developed country. So how to achieve that status? Whether to uplift the middle segment only, whether to uplift the higher segment only, we cannot achieve development. We able to achieve the real development, and we able to achieve the status of developed nation only when we pull the underdeveloped segment of the society. So we have to identify who is underdeveloped. And you believe it or not, this identification is not a hawk's call. This identification was done by the government by a very rigorous process. It's not an easy process. It's a very rigorous process. It's a very long way to go. It's a long term goals. 5 years, 6 years of research work, PhD scholars research work, juristic views, scholastic views, data collection. So we are trying from chaotic to simplification of the things. So in this process, we are pulling each and every segment who are in the underprivileged section of the society. So that is the result the EWS now highlighted. Because no one can deny that EWS now slipping towards the underprivileged. So we have to stop that also, because we are already pulling the underprivileged segment of the society, but at the same time, a community which may fall into the underprivileged segment, we have given the barricading on it.
Yes, sir, absolutely, sir. So the next question goes like, what was the motive of inclusion of reservation by the constitution makers? And what progress have we made so far apart from widening the scope of reservations that is provided?
Okay. Motive behind reservations. Now we have to see the root cause of reservation, stating the fact. How about the British era? Whether in a British era Indians were represented equally, whether Indians got the equal chance to be represented in the policy making, in the governmental functioning, in the governmental jobs, I'm sure your answer is no. My answer is no. They're not equally represented. Why we have provided the concept of untouchability in a constitution? Why there is a need? Why untouchability? Because the untouchability exists at that point of time. To how to eradicate untouchability. At the same time, there are some classes, just because of the caste, they were underprivileged. Just because on the basis of caste. So how to take them in a mainstream? We have to make some reservations for them. No? Otherwise, how the society is going to accept, whether voluntarily society is going to accept, because society themselves has boycotted that community. Because society has said only, okay, you are a certain class, you cannot enter here, you cannot come here.
You are not permitted here. This class of person is not permitted in a school. This class of person is not permitted to sit beside me. So the thought process of the society, how to change it. So at times the jurisprudential aspect says that sometimes society changes the law and sometimes law changes the society. So when we talk about society to be changed, so law has to come to the rescue. That is why constitution came as a rescuer to these community. Because if you go to the historical basis, no one can deny that they are underprivileged just because of being a caste. That is why in the beginning I said I am I am talking before the human beings, not on the basis of caste. So if everyone can adopt such approach, there's no need of reservation. Absolutely not required. So everyone has to be on the equal footing on that note.
Sir, so do you think that our constitution needs to be renewed, keeping an eye over the contemporary scenarios? And if you think that it should be done in that way, then what are the most vital changes which you think we should incorporate in our constitution?
Okay. Since the inception of our constitution, the present status till date, if you see, we have 105 amendments. Now, if you look very closely, why there's a need for 105 amendments? It's just in 1949 implementation of few provisions, and in 1950 the whole constitution came into existence. Since then till date, we have 105 amendments. That means what? That means the thought process of the framers of constitution, the vision is to a limited extent. The vision, of course, if we can see the things, we can see the things to a limited extent. But beyond that, we cannot see. Can you see your future after 5 years? If anyone is targeting for judicial services, whether he can be sure that, okay, after 5 years, I will be a judicial officer? Answer is no. So that is why when the framers have framed the constitution, they have some views in their mind. But as per the change of the society, the constitution changed with the passage of time. And at the same time, law is not static. Law is always changing. It has to be changing. Otherwise, there will be a collapse. So with the passage of time, as I am saying that we are in a phase of from developing to developed. So how to achieve it? Our law has to be changed. Our society has to be changed. On this notion, if you are aware, 2 days before, a petition was filed regarding the amendment of the Marriage Act, Special Marriage Act, so that the same gender can marry under the Special Marriage Act. So when it going to be happen? Then again, it's another dimension of the changing society. So law has to be changed. So that is a need of an hour. And at the same time, personally, I also in an opinion that whether I'm audible?
Yes, sir, you're audible.
Okay, I'm in an opinion that yes, like EWS has changed. Now we should shift our paradigm for the reservation on the basis of the economic condition. And definitely this is phase one, which is initiated by the government. And definitely we are going to see some other changes also in the future. That is one of the area which requires a complete reformation. Because at the same time, if you see the population of a country, it's growing like anything. At the same time, unemployment is growing. Crimes, if you see National Crime Record Bureau statistic 2021, increasing. So at the same time, we have to change many things. including the reservation system.
Yes, sir. So, the last question for the day is, what are the possible impacts of EWS reservation on the other prevailing categories of reservations, and if there is any?
Okay. Firstly, if you see the judgment, if you see the EWS category, per se there is no impact. But yes, if you see EWS, SC, ST, OBC, now they all are in the reserve class. And when, if you see that EWS also includes the general category, it's not about the general category is excluded. In fact, the SC, ST, and OBC excluded. So they are referring about the economic weaker section. So my point of concern is we are raising the bar day by day. 50% capping done by Indra Sawhney judgment. And then now we have seen the 10% capping. Maybe in future we are going to see another capping. So why not to remove the capping? Why not to remove the system itself and to search for the other way out, the other mechanism? Other mechanism of reservation should be on the basis of the economic structure of the family or an individual, whatever the case may be. So again, it should be based on the thorough research. Impact of EWS. Just to apprise you that after 2019, when this amendment has taken place, several people got the jobs under the EWS category, and definitely many of them are going to get the jobs in future also. So my concern is if the people are getting the jobs, I'm very happy. We should be happy. Getting the jobs from unemployment to employment, that is a task all of you are looking for. All of us are looking for, those who are unemployed. Whatever the basis may be, we should be able to lead a life which is full of fun, which is a reasonable life. Not higher, not lower, but a decent life. So for a decent life, everyone needs money.
Thank you so much, sir, for your intuitive articulation. And I feel it was really great to hear about the concept of inclusiveness, not exclusiveness, various excellent judgments, readings of various judges, flexibility, nuances of humble, and other laws which we have right now. And with this, we reach to the end of our webinar. I would like to extend my heartfelt gratitude on the behalf of entire council to our honorable speaker for sparing time from his busy schedule and enlightening us with his views. We'll be taking a lot of valuable insights from this discussion, obviously. And I will also like to thank the respected President, Ms. Aishwarya Bhatia, and Vice President of the Council, Ms. Devanshi Parasar, for their contribution in making this event a success. I want to thank the council members of National Judicial Reforms Council who worked really hard in handling with the nitty-gritties of this event. Last but not the least, a huge thanks to all our attendees who stayed with us throughout the discussion and kept it active and engaging with their opinions and queries. Thank you all and have a great day ahead. Thank you so much,
Thank you
sir.
very much.